This is the first in a series of videos on student engagement. What do I mean by student engagement? I mean, how can students, law students, engage with their subject matter so that they maximise their outcomes from the session? What I mean by this is we're looking at elements of law, knowledge, right? We're talking about applied knowledge. We're talking about skill sets, for example, presentation skills, for example, working in a team. We're talking about attitude, how they can maximise an outcome in terms of positive attitude. We're talking about confidence. How can they go into a session and draw from it some little element of confidence that just builds up their confidence level over all the sessions they do? And ultimately, I suppose there's the reference aspect. How can this session somehow contribute to the way that an employer down the line looks at them and goes, wow, this person's really got some skills, they've really got some knowledge, and I'd really like to employ this person. So that's what I'm going to do over the series of videos. Okay, let's get into the first element of student engagement, and that's with the very important issue of engagement with the law. Students, of course, have got to know the law. Now, what I often find is that when students turn up to my sessions, there will be a number of them who have read through the book and they will have an understanding of what it says on the page. They'll understand that, say, for example, on a particular area of law, we're going to look at recipient liability in a minute in relation to trust law. They will understand that there are three constituent parts. But what I really need them to know is, well, how do those parts relate to any set of facts? Can you take that law and then apply it to a particular set of facts, extract the key facts that are necessary to show that the offence has been met, and then can you apply those facts to the law and say, right, each one of the elements is met and therefore the offence is made out. Let's have a look at an example here. In the area of trust law, I was teaching this today, there is something called recipient liability, and the idea is basically this. There must be a breach of trust. What's usually happened is some property has been taken from the trust. Let's say a company, which can be a trust. Property has been taken from the company by a director. Then what happens is you've got receipt by the defendant, known as a stranger, because they are not immediately appointed as a trustee as part of the company. A defendant has receipt of this trust property. So what can happen is a director of the company can hand the property over to someone else. And then we've got the defendant has knowledge such that it is unconscionable for him or her to keep the trust property. So a lot of students will turn up to my sessions and they'll be able to tell me that. They'll be able to give me those 3 points. And then what happens is we give them a set of facts. And they have to look through those facts and they have to be able to extract the key facts that then show that the offence is met. So what you're basically doing is giving them a large set of facts like this, and from that they have to draw out the key facts to show that the individual parts are met. And this is what I mean by applied knowledge. That's what I want students to have, and that's what I really want them to strive to get before they get to the session. Pay a lot more attention to this, to the fact patterns, and be absolutely certain that what they can do when they get to the session is, can they look through the law and then go hunting for the relevant facts. It's an applied knowledge of the law. If you can do that, that's exactly what the examiner wants. When you get into the examination scenario, what will happen is this. You will then start gluing in the facts in here. So for example, we'll say breach of trust. Well, we say yes. Well, let's say director stole money from company. Tick. We've got that element. Next up, we've got receipt by the defendant of the trust property. Well, let's say director gave the property to Claire. Tick. We've got that element. Then let's say the defendant has knowledge such that it is unconscionable for him or her to keep the trust property. Now, unconscionability is one of those fluffy, stroke woolly tests in law, which doesn't actually mean an awful lot off the page. But what it basically means is that the defendant, their conscience must be affected such that they have some knowledge about the whereabouts of this money, and therefore they shouldn't be allowed to keep it. Well, what could we have? For example, Claire knew that the gift from the director was, for example, unusual. Claire thought it was unusual. It could well be that the director was her partner, boyfriend or girlfriend, and that Claire is not used to receiving gifts from this person, the director, and she thought it was unusual. Well, there you've got each element of the offence of recipient liability has been made out. So what I'm saying is that as a law student, what you've got to really try and do, really try and grapple with, is have an understanding of how this law applies to any set of facts, and to really get on top of it, so that you can go hunting very quickly in any set of facts and pull out those key facts there and glue them into the law. That's what you want to aim for, and essentially an answer in an exam would pretty much be like this. Law there, we've got elements of law here, the black stuff, law, and then you would immediately glue in some fact down there to show that that section has been met. And that comes down to Stephen Turner's essential formula to success on any law course. If you boil it down to the real constituent elements, it comes down to this. Law plus fact equals glory. If you can do that on a consistent basis all the way through your exams, you will do exceptionally well. Just remember, for every single bit of law that you're giving here, what you have to do is hunt down those key facts that show it is satisfied. And if, for example, you haven't got one, for example, you've got no information here about whether Claire knew about the shenanigans that have been going on with the gift, well, if you haven't got that element, you can say we're missing that. So on the facts, it doesn't look like recipient liability is made out. Okay, thanks very much. Take care. Bye-bye.